A new idea to deal with the Supreme Court's Carter decision on doctor-assisted suicide.
Our new proposal is to essentially have Parliament tell the courts, by putting it in the law itself, that it's enshrining the principle of the inviolability of life, which is a long-standing legal principle, which many of the interveners pointed to in the Carter case, in which the Attorney General of Canada also argued that this has to do with upholding life and so on.
In the news, we're in the middle of Life Tour. This week we hear from some of the volunteers and some of the folks who are showing up to listen. A new study confirms what parents intuitively know about universal daycare. Stay-at-home parenting has far superior outcomes. And a Calgary bus driver you've probably heard of is now a candidate in the federal election.
And now, Lighthouse News. Lighthouse News is a presentation of ARPA, the Association for Reform Political Action. Here's your host, Al Sebring.
We Need a Law's Life Tour is continuing this week. They started in Moncton, New Brunswick back on September 23rd. The tour has now visited 10 cities, including Halifax, Ottawa, Toronto, and Windsor. As we're producing this program, they're on the highway across the northern edge of Lake Superior, headed to Sault Ste. Marie and Thunder Bay. Then they hit the prairies, starting with Winnipeg and Regina. The tour features something that's never been done before, enthusiastic young volunteers who are helping people like Mike Schutten and ARPA lawyer Andre Schutten deliver the message. Stan Vane is one of those volunteers, 24 years old, from Chilliwack, BC. He says the stops so far have been all about engaging with people.
Some being pro-life, some being pro-choice, and some not knowing where they stand on the topic of abortion, and how so many were able to open up, share their experiences and their opinions with me. It all feels really good.
Shawnee Wildeboer is 18. She's from Ottawa, and she says there's one story from this tour that she'll never forget.
An encounter with someone right before a presentation, I guess. He saw our Life Tour shirts, and he asked me about it. Him and his girlfriend had been considering an abortion up until that point. He had thought there was no options left for him except for abortion, so I explained that there were other options and that there is help for him. And at this point, he got pretty excited, and he wanted to share that with his girlfriend. So he went home and shared with her. And later that evening, he texted me back saying that they would like to keep the baby.
Another volunteer, 17-year-old Angela Shaw from Lacombe, Alberta, says she's constantly encouraged along the tour by the wide variety of people who are showing up.
Even though there's all these people who are for abortion, there's still a lot of pro-life people out there. And they're not just old men like people would assume. There's all different age groups, and it's pretty interesting how they all come out to these events.
Those who've been showing up for the presentations are pretty pleased with the way things have been going. Peter Boss took in one of the stops in Ontario.
I was really encouraged to see different arms of the pro-life movement coming together, and I was really motivated to see how we can go out on the streets and effectively change people's minds with the knowledge that there are other pro-lifers doing a very similar thing, and there's groups working in politics and having laws being realistically put in place in the next few years.
And then there's a woman named Chantel who says this tour showed her again the importance of being faithful on the pro-life file, whether or not there's actual concrete cultural change.
We have to be that light in the darkness. John 1 speaks about the light shining in the darkness, and the darkness didn't comprehend it and didn't understand. But we still have to be that beacon, and we still have to show the truth. Whether or not the culture changes, that doesn't change our responsibility. The end result does not dictate our responsibility.
The tour finishes up next week with 2 stops each in Saskatchewan, Alberta, and BC. It wraps up October 17th in Vancouver. In other news, a new study out on the drawbacks of universal daycare. 3 academics, 2 Canadians and 1 American, looked at what's often touted as North America's leading universal daycare program. Proponents, including at least one federal political party in the current election campaign, say this kind of affordable universal daycare is what's needed across Canada, that kids actually benefit from it, both socially and in terms of getting them ready for kindergarten. Andrea Morozic from the Institute of Marriage and Families Canada says actually the study showed quite the opposite.
The conclusions they've come to over time here show that negative behaviors for kids, particularly boys, increase. For girls, they saw a decrease in what you call pro-social behaviors, which I take as being sort of academic speak for kindness, generosity, thinking of others, those sorts of things. The other thing that they note that is consistent with other research is that there's no lasting benefit for academic outcomes.
Morozic says proponents like to point to an experiment in the States, something called the Perry Preschool. Problem is, she says, there were fewer than 60 kids involved in that sample, and they weren't exactly typical of the overall population.
These children were very disadvantaged, and then what the Perry preschool program did was put extraordinary levels of intervention into those children's lives, and they worked with the parents at home at least once a week. So to me, it's a total fraud to take that and then say, we're going to apply this to the entire province of Ontario or to the entire province of Quebec and say it's going to work out in entirely the same way. That is disingenuous in the extreme.
Rosick says the study confirms what most people know intuitively, that wherever possible, the best care for preschoolers is delivered by a stay-at-home parent, not by a state-run child care system. And finally, you've likely heard the story of Jesse Rao, although you may not know his name. He was the Calgary Transit bus driver who lost his job this summer when he refused to drive a so-called rainbow bus, a city transit bus decorated with a rainbow flag in support of gay rights. Jesse Rao is now a candidate for Parliament, running for the Christian Heritage Party. He says the campaign's been interesting.
A lot of people recognize my story. Sometimes they don't recognize my face, but they've heard about me in the paper and stuff. And so as we talk, they're like, oh, you're that bus driver. So it's drawing good attention and awareness to the Christian Heritage Party. You know, I find that through social media and YouTube and Facebook that the serious Christians that aren't afraid to speak clearly on social, moral issues and issues that are facing the country, those kind of Christians are starting to connect with one another more and more.
Rao does admit that if somebody had told him 6 months ago he'd be a candidate for Parliament, even he wouldn't have believed it.
Politics has never been my passion, but this has all come about as natural as water finding its path down a mountain. I was asked to run, and I was convinced that I could be a louder voice for morality, so how could I turn that down, right?
He's running in the riding of Calgary Signal Hill. Chief opponent there, the Conservatives' Ron Leipert, a former provincial cabinet minister in Alberta. Back with more after this.
ARPA Canada is launching its 2015 Billboard contest. After a successful contest in 2013, we are once again calling for submissions. This year there are 2 categories. The first is pro-life, and the second is open to all other submissions. The winner of the pro-life category will receive an 8-inch Samsung Galaxy tablet, and the winner of the free topic category will receive a 10-inch Samsung Galaxy tablet. More details are available at arpacanada.ca/contest2015. Submissions will be received until October 23rd. We look forward to seeing your designs.
And we're back on the program. You'll recall that early this year, the Supreme Court of Canada issued its ruling in the so-called Carter case. The ruling struck down the Criminal Code prohibition against doctor-assisted suicide. The court gave Parliament a year, basically till next February, to come up with a replacement law on this. A few months ago, in July, ARPA released a position paper which said that the only way to preserve the notion of the sanctity of life, the only way to maintain the prohibition against euthanasia, was to invoke the so-called notwithstanding clause, Section 33 of the Charter, which says that in spite of court rulings or whatever's in the Charter, in other words, notwithstanding that, the notion of assisted suicide would continue to be outlawed. But now there's a new wrinkle on this. John Sikkema is a lawyer based in Toronto. He's done some research on this, and he's come out with a new proposal. Mr. Sikkema joins me on the program today from his home in Toronto. John, welcome to the program.
Thank you. Good to be here.
The last time I spoke with Andre Schutten and Mark Peniga, they were pretty convinced that Section 33 was the only way to get around the Carter ruling and to maintain the prohibition on doctor-assisted suicide. But you've come up with basically a different legal strategy. First of all, I got to ask you, what prompted you to do this research?
First of all, what this is really about is the role of and the relationship between Parliament and the courts. And that's really the approach that Mark and Andre were taking and which I'm building on. So what you have in a case like Carter is you have 2 laws in play. So the Parliament's role is, of course, to enact laws, and the court's role is to interpret and apply such a law. Now, in this case, we have 2 laws in play. That's the Charter and the Criminal Code, specifically the prohibition on assisted suicide. The one, of course, trumps the other. The Charter trumps the Criminal Code. And the question here is really, if one law is going to be valid in light of the Charter, it depends on 2 things. One, how the court interprets and applies the Charter, which is the supreme law. Second, on how the court interprets and applies the lesser law, the regular statute, in this case, the Criminal Code. So building on Andre's existing work, I started to look at what does the court say about that, both in its case from 22 years ago and more recently in Carter. What does it actually say about the prohibition on assisted suicide itself. How does it interpret that? And in light of how it interprets that, is there a way that assisted suicide can still be prohibited?
So, as plainly as possible, explain to me what your new idea really entails. What exactly are you proposing and how and why?
It essentially entails Parliament telling the courts why assisted suicide and euthanasia should be prohibited. It's up to Parliament to decide what principles to enshrine in law. The Supreme Court of Canada in Carter interpreted the existing prohibition as enshrining essentially the principle of protecting autonomy. So the court looks at the existing limits on complete prohibition on assisted suicide and euthanasia and says what this is really about, although the law doesn't say explicitly, is protecting the autonomy of vulnerable persons. We don't want anyone to be either murdered or pressured to commit suicide against their true personal desire. And it says that we think, based on our reading of the text of the law, is Parliament's objective. Now, that's Parliament's objective. The court doesn't decide what the objective of a law is. It's up to Parliament to decide why to prohibit something like assisted suicide or euthanasia. And our new proposal is to essentially have Parliament tell the courts, by putting it in the law itself, that rather than enshrining the principle of autonomy, it's enshrining the principle of the inviolability of life, which is a long-standing legal principle, which many of the interveners pointed to in the Carter case, in which the Attorney General of Canada also argued that this has to do with upholding life and so on.
So basically what you're saying then is to write the law in such a way that the whole notion of protection of life becomes the purpose of the law rather than the court's inference about protecting the vulnerable. You know, when I talked to Andre and Mark back in August, we talked about Section 33 and the political problem with that because A, it's never been used federally, and B, a law like that has to be renewed or refreshed every few years. This might be a lot more politically palatable, right?
That's an important question. I do think it's an easier political sell. I think the most obvious example, which is quite recent, it was passed in 2014, was Parliament's response to the Supreme Court's prostitution ruling. If you look at Parliament's response to that ruling, it actually enacts a law that's stricter than the law that the Supreme Court had struck down. And it does so for essentially moral reasons. The principle that the autonomy to sell one's body or to purchase another person's body for personal pleasure is subject to moral concerns about the inherently demeaning nature of prostitution and all of those things. So there are cases where fundamental societal concerns, moral concerns, can actually limit autonomy. And of course, laws in all kinds of ways limit our autonomy. So that, I think, is a good example of where Parliament has responded with a kind of a moral objective in its law.
But given the history, is it reasonable to expect Parliament to take a firm stand on something like a moral objective? You know, the history on this isn't particularly stellar, given that our parliamentarians have been pretty hesitant to make any moral statements in law for the past 20-plus years on the abortion file, for example.
This is not at all like abortion. And I don't mean that from a principled perspective, more from a political perspective, in that the Morgentaler decision in 1988, which struck down the existing provisions in the criminal code on abortion, there was already a very liberal regime in place. It was quite easy to get an abortion in Canada. Doctors could give abortions for health reasons, which were not defined. The psychological health of the mother could be a good enough reason. There was really no limits on abortion effectively there, except for some administrative hurdles that people had to jump through. So we went from a very, very liberal regime to no law at all. And then we were dealing with the political situation after that. This is a very different scenario. We've always had a complete prohibition on assisted suicide. So we're not coming from a liberal regime and trying to make it stricter. We're going from complete prohibition and repeated votes by Parliament in favor of such a prohibition. In fact, overwhelming votes from multiple parties. The 2010 vote on it had support from Conservative Liberals and NDP against legalizing assisted suicide. So politically, it's a very different scenario. So I'd like to be optimistic about it. I think people should be optimistic. It will certainly take some advocacy. I would hope people don't get discouraged based on the record of parliamentary votes on this, and also based on the success of the parliamentary response to the prostitution ruling. I think there's reasons to hope.
John, thank you very much. We're out of time.
Thank you.
We'll be following this.
This has been Lighthouse News, delivering news and commentaries on today's current events to equip Christians for their task in the public square. Production Manager Brian Grimm. Technical Director Nate Bosher. Questions or feedback? You can leave us an audio comment by clicking on the answering machine button at the top of the Lighthouse News homepage. Or you can send us an email, info@arpitcanada.ca. Be sure to join us again next week for another edition of Lighthouse News.